everyone. Welcome back to The Connection Effect. Today's episode is going to be a little different. This podcast has always been about the process of healthy conversation, active listening, curiosity, emotional regulation, more than the content of it. But today, for the first time, we're going to do both at once. Because there's no better way to show what curious, good faith conversation actually looks like than to put it to the test, talking to people when you actually disagree about something. A few episodes back, Monica Guzman and I talked about exactly this, how curiosity is the tool that lets us stay in hard conversations instead of retreating from it. Today is that idea in practice. This won't be a debate. I wasn't trying to convince my guest of anything, and he wasn't trying to convince me. It's two people modeling what it looks like to stay curious about a subject that a lot of people have strong feelings about. That subject is the Supreme Court. So a quick note on what this won't be. We're not breaking down individual decisions, and we're not talking about how any specific justice has ruled on any particular case. We're talking about the court as an institution, how justices actually decide, and what factors come into play. The conversation stays legal, not political. My guest today is esteemed attorney Daniel Levin. Dan represents corporate and individual clients across a range of criminal and civil government matters. He's held senior roles across the federal government, including Chief of Staff at both the FBI and the Department of Justice, Senior Associate Counsel to President Bush, and Legal Advisor to the National Security Council. He's also argued before the Supreme Court himself. I asked Dan to join me because of that vantage point. Decades spent close to how power and institutions actually work at the very highest levels. But honestly, the real reason he's here is simpler than that. Dan and I were friends back in 4th grade when he first taught me how to play chess. We lost touch for almost 50 years and reconnected a few years back. So this is just two old friends talking through something hard, the way I hope more people feel free to do. Dan, thanks for being here.
Thanks very much. It's a pleasure.
So, my gosh, I think we have to start with your experience in government in just a brief sense. You were Chief of Staff at the FBI. Can you tell us what that role included?
Sure. I started there actually on 9/11. Bob Mueller, who's was an old friend, unfortunately since passed away, started about a week earlier. I've worked with him in a number of different government jobs, and the plan was for me to come over and work with him. And then because of 9/11, we started it on that day. And it really was helping Bob with all aspects of being the director of the Bureau, which was really sort of two parts. One was the day-to-day work, and especially the response to the attacks of 9/11. And then the second one was a series of reforms he was trying to do to move the Bureau forward and into more modern technology systems and the like. So it was really across those two broad categories of activities.
Now, you were also Chief of Staff at the Department of Justice. And during what years were you there?
It's going back a long way. So it was 1991 to 1993.
What was the role of the Chief of Staff at the Department of Justice?
It was similar. It was sort of assisting the Attorney General at the time. That was Bill Barr in his first stint as Attorney General in really all aspects of the Justice Department. So, everything would funnel up through the deputy to the Attorney General, and I would be part of the process of giving him staff assistance, making sure everything had been looked at properly, and giving him my 2 cents for whatever that was worth.
Right. I was hoping you threw in the 2 cents because some people would think of Chief of Staff as an administrative position or it's more process oriented, but certainly there is a huge amount of content in terms of that role.
It depends on the principal. So I think people use their staff in different ways. Both Bill and Bob, obviously part of my job was making sure the paper was flowing, things were getting where they needed to get. But also what makes the jobs fun are they both were friends as well as bosses and were interested in what I had to think about things.
And can you give us a sense of just what the general makeup is of the Department of Justice?
It's both criminal and civil. It represents the U.S. government on both sides, and it has a number of components. The FBI the Drug Enforcement Administration. At the time, it had the Immigration Naturalization Service that has moved since then. And so its work was, it has a policy function, which has helped implement the administration's, the president's criminal and civil law policies. And then it has a large enforcement component, which is, and historically has been largely non-political, just enforcing federal laws, both criminally and civilly, and then defending the government when it gets sued, as it does on a regular basis.
And then can you give us context on what that is in relationship to our three co-equal branches of government?
Sure. So the Justice Department is part of the executive branch. It implements laws passed by Congress as well as executive orders and executive procedures, and it represents the government in courts, which is the third branch, both offensively, or when the government is the plaintiff or the moving party, and defensively when it's getting sued. And that litigation can take place in any of the federal courts up through the Supreme Court. There's a special office in the Justice Department that handles the Supreme Court, the Solicitor General's office, and also in state courts. The Justice Department gets involved in state courts from time to time.
So the judiciary, which is the third branch, and particularly the Supreme Court, is going to be the topic of today's conversation. And the reason I chose that is only because I look at the world today and people in it and what they're talking about. And there's certainly great concern about the political situation, our role with the rest of the world, which I believe is just a part and parcel of an evolving society, that there are complexities out there and people have issues and concerns. But the one concern I hear a lot is about the Supreme Court. So I want to focus on the conversation today with you on that. First, let's just start at the beginning in terms of how judges decide, in particular the Supreme Court judges. So we have a constitution, and there's different perspectives on what the role is of a Supreme Court justice. Can you share with us a few of the different ways that a Supreme Court justice could approach decision-making based upon the Constitution?
Sure. So there are a lot of different schools of thought of how judges, or in the Supreme Court justices, they're called, do their job. And obviously there are 9 justices currently, and there have been many more over the years, and they're not all the same, and they do things differently. But in general, there is what you might call kind of the non-legal approaches. There are some schools of thought that say judges basically act as political actors, not legal actors. This legal realism, this is sometimes called. And sometimes not just political actors, but partisan political actors. Republican judges rule a certain way because they're Republicans, and Democratic judges rule a certain way because they're Democrats. I personally don't believe that to be the case in the overwhelming majority of judges or cases, but there are people, smart people, who think that, and I think it's something that's important to keep in mind. There's also what you might call the Marxist interpretation of judges, which is that judges are part of an economic system, and their role is really to perpetuate the status of the economic classes that are currently in charge. Those are both in my mind, and there are some other similar theories which are, I'd call, non-legal. I don't buy those personally, but as I say, there are people who do. In terms of legal analysis, what I would say where judges are trying to interpret the Constitution, statutes, as sort of lawyers or judges, there are, you might say there's sort of 3, there are more than 3, but I'll say sort of 3 main approaches. There's what's called the originalist approach, which tries to look for the intent of the people who either passed the law or adopted the Constitution, and say that that's what governs. What did they mean, back in the late 1700s, or whenever amendments were passed, whenever statutes were passed. There's a textualist approach, which is not so much trying to look at what they meant, but what did the words that they adopted mean? So we're not really trying to go beyond the text of the statute, although you have to look some at the history to understand how words were used at the time. But what they did is, they passed a law or an amendment. It has words. What do those words mean? And we're bound to do our best to just interpret those words. And then there's what's sometimes called the living constitution approach, which is that those words, especially in certain provisions like due process or equal protection or cruel and unusual punishment aren't limited to what they meant at the time they were adopted. They are more implementing large principles, and that those can change over time. So that what was considered cruel and unusual punishment back in the 18th century doesn't govern us today because the world has changed and we've adopted and evolved. And those are kind of the broad categories, I think, of how justices can look at laws and try to come up with a decision in a particular case.
So let's talk about those three legal theories. Generally speaking, do justices that want to be on the Supreme Court, do they announce what theory they espouse? Are they known as, I'm an originalist, I'm a textualist?
Well, they're typically known as that, although it's usually not sort of an announcement. I mean, people may, in confirmation hearings say it, but most people on the Supreme Court, I'm trying to think of, have been judges before they become Supreme Court justices. And so they've written a number of opinions over time. And so people can read their opinions and see how they tend to approach legal analysis. Now, it's a little bit different in lower courts because they are supposed to be bound to apply the decisions of courts above them. It's a hierarchical system. We have trial courts, we have 12 courts of appeals, and then we've got the Supreme Court, which sits on top of the whole thing. And so a lower court judge might think a particular thing, but he or she is supposed to be bound to apply the law as it comes down from above them. So maybe a little bit harder to figure out what they really are thinking. But you can usually get a pretty good sense from how they write their opinions. Do they seem to be basing it on the text of the statute or the Constitution? Are they more talking about how things have evolved or changed over time? Are they looking more at legislative intent? What were the people saying about the law as opposed to what the actual words in the law are?
So it's fascinating to me that you could have a justice that can look at it three different ways, and I'm presuming if they're an originalist, that they stay an originalist, that they don't change decision to decision. But actually, let me ask you that. Do you find that justices sometimes, the end justifies the means? They want to come up with a particular decision, so therefore they talk about the original intent of the framers of the Constitution as opposed to just, the words themselves?
So certainly there are many people who think that's the case. And they think a lot of judges are result-oriented, and I'm sure some are, especially if you look at the full range of the federal judiciary. I'd say a couple of things. One is I think it's good for all of us to have a lot of humility when we talk about this, and not to ascribe bad motives to people who may come up with decisions that disagree with us. And this is especially true. Law is not like physics or chemistry where there's a clear objective answer to a lot of questions. It's subjective, and smart people, reasonable people can come up with different conclusions. And it's easy to say that the judges who rule the way you think is correct are applying the law, and the judges who rule the other way are result-oriented or not applying the law or being partisan or political. And I think that's unfortunate. And I think even sophisticated observers of the court, when they write about judicial decisions, often talk about them as if they are political decisions rather than legal decisions. And as I said, there are people who believe they are. I don't. I think they're actually legal decisions. But I think it's unfortunate to treat them as if they're all just, the conservative judges want the president to win. The liberal judges don't want the president to win. I think they're all doing their best to try to apply what are unclear and often kind of vague and broad rules in complicated situations over changing periods of time. But do judges change? Sure. Some judges change. There's something used to be called the Supreme Court effect. The judges who seemed to be a certain way once they got on the Supreme Court turned out to be different. And conservatives often complain that, so-called conservative judges get more liberal when they get on the court. Liberals, I'm sure, feel the opposite. I think people are just sometimes disappointed. And I think it's more, the judges are trying to rule correctly in complicated situations, and nobody's going to please everybody sort of all of the time. And so I think there have been some changes over time as judges sit. The other thing to remember is judges have lifetime tenure. So once they're there, they're there. Short of impeachment, they never leave. And so they can evolve. Their thinking may well change, and they're not trying to please anybody because they don't have to get reelected or reappointed. They're free to rule in the way that they think is correct.
I want to go back to the those three different ways to look at the Constitution because they are profoundly different, particularly those that believe that the Constitution is a living, breathing document. The framers couldn't possibly have predicted or expected society to evolve as it has, and therefore the document has to be read and constructed consistent with who we are today as a people, versus those who are looking at the words of the document or the intent. What's your sense on how justices followed one of those ways compared to the others? Is it a philosophical difference? Is it the way they were trained as young lawyers? Because that's just such a different way to look at the document.
So first of all, let me lay out my bias here because we all have our own biases and people listening should know. I'm a textualist. I think you should interpret statutes and constitutions based on the words that are in them. And one reason why I think that is the judiciary is the least democratic branch we have. They get appointed and confirmed in a political process, but once they're judges for life, at least in the federal system. They're unaccountable really to anybody, especially if they're on the Supreme Court. And so I think it's important to try to limit their discretion somehow. And to me, the best limit is trying to at least tie them to the words of whatever it is they are interpreting. That said, a lot of judges and lawyers think the opposite, think that that it is a living constitution, you have to adopt it. And I think there are two different pieces of that. One piece is sort of the trivial one. There were no telephones when the Constitution was adopted. Obviously, to apply search and seizure to telephones, you have to do something. You can't say, what did the framers mean? Because they didn't mean anything about telephones because they didn't know. You can say, yes, but we're going to try to adopt the principles of what unreasonable search and seizure meant back then and apply that to a telephone. Or you could say, we're not really bound by that concept of what unreasonable meant back then. We are free to be more expansive in what it means. To me, the concern about that is then it sort of means whatever five justices say it means. And as the old saying goes, the Supreme Court is not final because they're right because they're final. Because whatever they say is what the Constitution means. And if that's the case, it can flip back and forth very easily. And if you're happy with a liberal or conservative ruling in one direction that's not sort of tied to the words of the document, presumably you have to be willing to accept it in the other direction. That's also not tied to the document. But how do judges become the way they do? I think it's the way people develop their own personal philosophies in any area. Some people are more attracted to the idea that as judges we have limited power and we're bound by the words. Others are more attracted by the idea that our job as judges is to do justice and that requires more flexibility in how we apply statutes or constitutional provisions in particular settings. And indeed, the world is vastly different than it used to be. It's extremely difficult to change the Constitution. And so we have to have some leeway in how we apply it.
So as a textualist, when faced with a situation that didn't exist, let's say technology, when the framers wrote the Constitution, and you believe that judges should be limited to the words, can I presume then that you believe that's where the legislature should come into play if they're unhappy with judicial decisions that are based on the text? They feel that then we'll just have to make new legislation to sort of deal with that new technology.
So I think that's a complicated question because it depends. If it's judges interpreting statutes, then sure. If there was a law passed in 1865 and the judges say this word in 1865 meant X, and the Congress thinks, well, that's not what we want it to mean now, they can amend that law and now that word can mean Y. If it's the Constitution, of course, the legislature is not allowed to change it. Now, there may be some wiggle room or some interstices between constitutional provisions where there's some room for legislative action, but it's a lot harder. And it's one of the reasons why, my own view is you should be careful about interpreting the Constitution precisely because it is so hard to change. And once you've embodied something in the Constitution, it really limits social action in a way that a statute doesn't because Congress can't change it. I hope we'll get later on to Congress, the role of Congress, because I think one of the problems in recent decades is that Congress has largely abdicated its responsibility or failed to fulfill its role in passing legislation. And this is hardly a unique view on my part. I think Many people talk about the failure of Congress to be able to kind of pass legislation. But I think it's able to do that where there are statutes involved. It may be difficult, but it's able to. Where it's a constitutional provision, its ability is limited.
So you've got three legal ways to look at the Constitution. You mentioned a couple of non-legal ways. I'd like to talk a little bit about that because judges are human. They're coming in to their job with a political, ideological perspective. Do we expect as a society for them to park that and not have that influence their decisions?
Well, I do, and I think a lot of lawyers do. Whichever legal approach they take, I would say their personal views should not be influencing their legal judgments. So I could easily imagine a judge, for example, say, I personally am pro-choice, but I don't think the Constitution provides for a right to abortion. Or I personally support gun control, but I think the Constitution doesn't permit this kind of gun control. My personal views don't really matter. Or the opposite, exactly the opposite. I'm personally pro-life, but I think the Constitution does provide for a right to abortion. I don't think we want judges letting their personal views influence how they interpret the law, because then every judge will interpret the law differently based on whatever he or she happens to think is the right answer. And they're not legislators. If they want to go influence the law, they can go run for Congress or president or whatever else. But as judges, their job is supposed to be to interpret the law. And as I said earlier, if you don't limit them, if you really do just grant them total discretion, if you just said, judge's job is to do whatever they think is right in any given case, you've now got somebody with lifetime tenure and no control over them, and they can do whatever they want. And if they happen to be doing things in the way that you personally like, you may be happy with that. But if they're doing things in ways you don't like, you're kind of stuck. So I think we do want judges to try to park their personal views. Is it realistic to expect them to? Probably not in every case. As you say, they're human. We're all human. We all have our biases and we all have our own beliefs and things. And it's easy to, if you're thinking this is what the result should be, it's easy enough to get there, even if you're pretending to be interpreting the statute directly. You can sort of twist how you do it along the way. And I think it happens some. I think it's unfortunate when it does, but I think it's, as you say, they're human beings too.
So I'm going to come up with a couple other factors that could influence them and just get your take on that. Political atmosphere, pressure from the public, pressure from the media, pressure from the president.
So this is what lifetime tenure is supposed to remove them from. Since they can't get fired, they don't have to get reappointed or reelected. They're supposed to be, and that was a conscious decision by the framers, to remove them from political pressures, partisan political pressures, public pressures. And I think it works to some degree. But again, they're human beings, and they have families, and nobody likes to want their family to read criticisms of them as horrible human beings. And does it ever affect how they rule on things? I'm sure it does sometimes. Hopefully not much, hopefully not at the Supreme Court level at least, but they are people. That's why the system was designed the way it was. And a lot of state judges are elected. There, I think it's much, much harder for them to withstand political pressure because, if there's a criminal case and there was a mistake made by the police and the case should be thrown out, but there's a lot of public pressure to see the person sent to jail, it's tough for a judge, I think, to say, I'm going to let this person go, even though they clearly are guilty because there was some screw up along the way, which is what I'm supposed to do because I'm, up for re-election next year.
I want to continue with these other factors that are non-legal that you have, and we talked about their personal ideological views. We talked about the political atmosphere that you believe should be put aside. What about their goal to protect the institution? And the institution has been under attack. And what about making decisions to protect the integrity of the institution? Do you think that's a proper consideration?
I don't personally think it's a proper consideration. I do think it sometimes comes to play. And I think it's easy to attribute that motive when a decision comes out different from what you had wanted it to come out and say, well, all they're doing is trying to protect the institution. But I know there are conservatives who say that about Chief Justice Roberts, who I actually have tremendous respect for. but that sometimes he rules in a certain way to try to protect the integrity of the Supreme Court. I think more often what they try to do is either limit or tailor a decision that don't change the result, but try to make it narrower to try to avoid criticism that they're going further than they need to go, or try to build a bigger coalition so it's not always 5-4 or 6-3, and they may change the opinion in some ways to get more justices to join in. There was, again, I believe it's true, back in Brown versus Board of Education, where the Supreme Court overturned the decision that said separate but equal is okay, that there was a huge effort to make that a unanimous opinion, and that the Chief Justice really went around and pressed very hard for justices who might have some minor disagreements with it to join in so that it could present a unanimous Supreme Court on what was going to be an extremely politically controversial decision.
So when we're talking about protecting the integrity of the institution, the Supreme Court, can you give our audience just some examples of how that would play out, or what that would look like?
Sure. So, one of them was that the Brown versus Board of Education one, where they were trying to get unanimous decisions. I think there are some people who say, like maybe the Federal Reserve decision, without getting into the details of any of these decisions, the Supreme Court has generally been saying recently the president has authority to fire heads of departments of agencies in the executive branch, even if they were so considered, independent in the past. And there are a number of statutes that say you can only fire them for cause. And the Supreme Court has generally been adopting what's called the unitary executive theory, which is the president is the head of the executive branch. He has all executive, or she has all executive authority, and can fire at will the senior people who report to him or her. And the court has mostly said that. They came out differently on the Fed. And a lot of people on the right, at least, think that was an unprincipled decision, that the correct legal decision would have been to say he can also do the same with the head of the Fed. And some people say the reason they came out differently was the Fed is so important and the independence of it is so important that the court would look too much like it was just doing whatever the president wanted if they ruled in his favor on that. The same with birthright citizenship. Some people have said that the court ruled the way it did because it wanted to protect its independence or looked independent from the president. The Fed one, I'm not sure. The birthright citizenship, I don't believe that was the decision. I think they read the Constitution, they read the statute, that's where they came out. And whether you agree or disagree, I think it was I don't think it was a politically motivated decision. I think it was a legally motivated decision. But those are the kinds of things that can happen where you could see why the court might want to avoid looking too much like it was in the president's pocket, so to speak. I think Bush versus Gore, was an example of one where I think the court was trying not to look like it was just picking who the president was going to be. It ultimately ended up having to do it because it's sort of, there was nothing else to do. But I think it was trying earlier on to avoid having to do that. I think that's probably a wise instinct. I think at times, you don't really have the option.
I have one more factor that is non-legal, and I just want to get your take on it. That is when perhaps the peer dynamics amongst the Supreme Court justices, they want to build a coalition. And I don't know if that's decision trading. I'll do this on this one, and you've got my back on the other one, or just conversation amongst them, between them, that are beyond just that decision. Can you talk a little bit about that?
Yeah, the honest answer on that is I don't know. You hear about that happening. It's possible it does. I'd be a little bit surprised if it does, but it's, nothing's impossible, and there are some people who claim it has happened. I think it's more likely that the coalition building goes about how to frame a particular decision rather than like trading votes. I'll vote your way on this one, you vote my way on that one. I think in Congress that clearly happens. It's clear that members of Congress will trade votes that way. And I'm not sure it's even inappropriate in the congressional setting. It's a political process. The courts are supposed to be a legal process, not a political process. Congress is supposed to be a political process. And so trading votes is, that's part of a political process. But I think it may, there are people who believe it happens on the court. I personally don't think it happens that way, but I can't know for sure.
So we've got two sets of factors here that perhaps guide or dictate how a justice would decide. You've got the legal factors, whether or not the Constitution, what the intent was, or what was the text, or it's a living, breathing document, and what should it be today based upon our current society. And then you've got these other factors which you feel shouldn't impact the decision, but because these justices are human, do to some degree. So I'm thinking that maybe instead of saying the non-legal factors are never there, but maybe just to recognize they are, and there's a ratio between the two, or they're both present, and we can't ignore that, but you want the legal factors to outweigh the non-legal factors. What's your take on this combination that these justices are human, there's legal and non-legal factors, and are they going to be outcome determinative by the non-legal factors? Are they going to say, well, I'm a conservative and I do believe this and I agree with the current president and I'm going to rule that way and I'm going to say it's because that's what the original text said? Can you talk a little bit about what you think the ideal scenario would be? And then I want to talk about how you think of it in the current context of the current court.
I think the ideal scenario would be to limit consideration to the legal factors in whichever of these different philosophical approaches you take. I think letting in non-legal factors is really sort of opening a Pandora's box, and it then becomes very difficult to control which ones can or can't be considered or how much they can, 10%, 12%, 50%. Do I think sometimes these non-legal factors come in? Sure. Judges are no more perfect than I'm perfect or anyone else is perfect. Even if they wanted not to think of those factors, it would be hard to keep it out of your head because, it's in there. And I'm sure at times, especially in lower courts in dealing with individuals, I think there's an element of, I want to do what's right here. I don't, it's not that I don't care what the law says, but I'm a judge. I have the ability to sort of do what's fair and what's right in this circumstance. And when you're dealing with individual cases, that troubles me less because it's, I had this when I was a prosecutor. It was clear to me there were times when judges gave sentences that were more lenient than the law sort of prescribed because they felt badly for the defendant. They wanted to give him or her a second chance. And although I disagreed with it as a prosecutor, I fully understood it. And, I think it wasn't an unreasonable thing to do. I think for the Supreme Court, which is laying down rules that govern everybody and, that they're not going to get back to very often so that it's rules that will be in place for a long time. I personally think they should be doing everything they can to try to limit those non-legal factors, recognizing that, they're human beings too. But that's kind of, if you ask me what I think the ideal is, that the ideal would be not to consider them, recognizing that sometimes we all fall short of the ideal.
All right, so let's take all this background and talk about today's Supreme Court. You've got a lot of folks on the left who think that the court has become political. It's an extension of the president's wishes. And I'd love your take on that. Clearly, we're not going to go through all the decisions. I think a broad strokes response on just generally, are you seeing these non-legal factors coming into play in this Supreme Court, as opposed to the legal factors, which that's how these justices, or the majority of them, are reading the Constitution? Because I think people will default, if the ruling is against what you believe, to thinking that the decision was not based upon merits or upon the legal reasoning, but it was based upon politics. So let's start this conversation.
Yeah, so as I mentioned, I think earlier, I think this is a really unfortunate, I'm not sure it's a development. It's probably been the case for a long time. Exactly what you said. If a decision comes out the way you think is correct, you think that was a good legal decision. If a decision comes out opposite of what you think is correct, it's very tempting to think they're wrong on the law and they're also badly motivated. They're doing it for political reasons. So not only did they get the law wrong, but they're just partisan hacks. That's not how I see what's going on now. Now, admittedly, I tend to be a fairly conservative jurist. I'm a textualist, as I said. I'm an executive power person. But I also think it's important to take a little bit of a bigger perspective here, because, the headlines will be Supreme Court rules for Trump on X. Well, in the separation of powers context, they're not ruling for Trump. They're ruling for the president. And whoever the president is next is going to have those exact same powers. And so if you say the president can fire the heads of departments of agencies, right now that's President Trump. If President Biden had won, or President Harris had won, or whoever comes next is a Democrat, they'll have that exact same set of powers. It's not going to be a different rule. So I think some of the decisions, especially in the separation of powers context, are not partisan political. I don't even think they're political, but even if they're certainly not partisan political. I also think that decisions people sometimes think of as being more partisan are very difficult to predict what the partisan impact is going to be. So let's take a couple of examples. And again, I'm not arguing whether any of these decisions are correct or incorrect, but campaign finance. There was a long period of time when Republicans sort of outraised Democrats in sort of big contributions. And so it was easy to say that some of the campaign finance decisions that allowed for more big money into politics were pro-Republican. Then that flipped around for a while, and there was a period when the Democrats were outraising the Republicans. Same decisions still applied. Then it seems to have flipped back a little bit. But it's not clear that decision inherently helps either Republicans or Democrats. It's a decision on what the First Amendment requires, and it applies neutrally across the board. And there are times when one party's been helped and the other one hasn't. Gerrymandering is another one. I used to joke, and Eric Holder is somebody I have a lot of regard for, but I used to joke that you could tell who was winning the gerrymandering battles by how vocal he was being. So there was a period where the Republicans were out gerrymandering the Democrats, and he was very active saying, you shouldn't have these political gerrymanders going on. Then the Democrats actually pulled ahead of the Republicans for a while in gerrymandering. And I'm not an expert in this stuff, but I have friends who follow this closely. Now the Republicans have pulled ahead again. But the decisions themselves are not inherently Democratic or Republican. They're neutral on their face, and in fact, at different times, they help different people. My own view is that the decisions are being motivated on both sides by genuine belief in how the Constitution reads or how the statutes read, not by, does this help Democrats, does it help the Republicans, does it help the president, does it help the Congress, at least most of the time for most of the judges. I'd say another thing, like the complaints about the so-called shadow docket, which have come up a lot recently. I for one don't really like the term because I don't know what's shadowy about it. I mean, they're public opinions, exactly who voted for what. It's not like the Star Chamber where they disappear and all of a sudden something happens. But it is interesting that, of course, the people who complain about the shadow docket only complain about it when they lose. If it's a shadow docket ruling that they win, they're not complaining about the use of the shadow docket. And so I think it's easy to complain when you lose. I think it's not helpful to accuse the other side. And I know this is sort of right up your alley generally. You can disagree with the result without thinking that the people on the other side are bad people. And I think it would be much more healthy to have legal debates on the merits of the law than to sort of say, well, this side is the law and that side they're just being partisan political hacks.
Are there any decisions or series of decisions that you've read from this Supreme Court where you believe that politics came into play and it concerned you?
I don't really think so. I think there may be as I mentioned, the Fed decision may be one where there was some, not partisan politics, but non-legal political considerations in play. I'm not sure that's right. And, again, I'm a big fan of Chief Justice Roberts, and, I think he's a very, very smart guy. He's certainly a smarter constitutional lawyer than I am. And so I may be being unfair on that one. I do see it more in the lower courts. And I think there have been a number of lower court decisions which I view as just political in the sense that the judges who issued them had to know that they would get reversed on appeal. And in theory, a judge should not enter a decision that he or she knows is going to get reversed on appeal because they're supposed to be bound by the courts above them. And so I think those were unfortunate. But, that's I don't know, there are hundreds of federal judges. And so that's a much harder, there are bound to be some, who are less, I don't know what the right word is, are more willing to sort of let their political views come into play. And I think some of them think they're doing it for the right reasons, that, even if the Supreme Court or a court above them is going to reverse them, they need to sort of, put on the record their views on this legal matter. That's where I've seen political decisions more often. But at the Supreme Court, on either side, I can't think of one that I think is, again, I know a lot of conservatives who are very upset by birthright citizenship. I think it was a perfectly reasonable decision, whether it's right or not. You could come out the other way, but I think it was a perfectly reasonable decision. And I don't think it was politically motivated. I think they were interpreting the Constitution.
I do want to talk about one category of cases, that's executive power. And people do feel as though that our current president is exercising more executive power than other presidents have done historically. And they are unhappy about it if they're not a supporter, and they're happy about it if they are a supporter. And so what's your sense on how the court is treating executive power generally? And then I'm going to talk about historically in a moment.
So I think there are kind of two parts of it, or two aspects, significant aspects of executive power. One is this sort of unitary executive, which is whatever executive power is, who gets to wield it. And the unitary executive theory is the president yields it all. And it's really all ultimately his or her power. And if Congress tries to peel little bits of it off and create these so-called independent agencies, they can't do that. There are just three branches of government: executive, legislative, and judicial. There's no like 1.5 branches, part this, part legislative, part executive. And I think there the Supreme Court has largely ruled in favor of the unitary executive. Now, I think, frankly, they would have done that in the last administration if the president had tried to fire these people. And so part of the reason these are being brought up now is because President Trump's the first one who's sort of exercised that power and challenged it. And he's challenged it in a concerted way, because there are people advising him, or he himself genuinely are of the view that there is a unitary executive and that's how power should be exercised. But I don't think that's particularly, as I say, it's not partisan, because the next president of whatever party will have that exact same power. There's a second piece of executive power, which is whether or not it's unitary. Like, how broad is it? Like, what can the president, and this is where like the tariffs case comes in and things like that. How much power does the president have? And I think there the court has been less deferential to the president. Sometimes it rules in favor and sometimes it rules against. I think this is one where we talked about before, Congress's failure to act in some ways encourages presidents to be more aggressive, because nothing's happened. If they don't do something, nothing gets done. And so it's interesting to see if the court defers to that at all and recognizes that if we say the president can't do this, Congress has to, and Congress doesn't do it, then nothing's getting done. So far, they seem, I think, to be taking, sort of a middle ground approach to it. So I think in terms of the scope of executive power, the court's been more nuanced and hasn't got like a single theory of it. And I think that's consistent with sort of separation of powers, which is a little bit messy. The Constitution, some things are very clear who has power to do things. And then there are these like places in between which are very unclear. And it's sort of a struggle between the branches. And I think in a lot of those areas, the court ultimately will say, it's not up to us to decide. That's a political issue between the branches. In some areas, it'll say, that is up for us to decide, and this is how, like the tariffs. They could have just said, we're not going to deal with it. That's between the president and Congress, and we'll let them deal with it. But they didn't. They said, no, the president's overstepped his constitutional authority. Birthright citizenship's a little different, because that's not between the president and Congress. That's between, in that case, the president and individual people who were born here, and were they citizens or not. And so there, the Supreme Court needs to deal with it, and it did. And it dealt with it under the Constitution. The 6th justice dealt with it on the statute, but 5 justices said the Constitution provides for citizenship.
I want to go back to the sort of almost political storm around people's voiced concerns that this Supreme Court is political or is being influenced by politics. Do you see that issue is greater today than it's been in the past?
Yes, I mean, I think it's been growing over a period of time. I think if you go back to the 50s, say, it wasn't that the Supreme Court didn't make political decisions in politically sensitive cases. There tended to be much more, this is true on both sides, I think, respect for the institution. And people, even if they disagreed with the decision, were much more likely to say, well, that's the final, the Supreme Court spoke, and that's the final word on it, and not attack the justices. I think this is just part, unfortunately, of a trend, and I know you talk about this a lot, a generalized trend of things becoming much more divided, much more bitter and hostile, the two sides getting kind of further and further apart. So I think in more recent years, and it's not just in Trump, I think this is going back a ways as well. I mean, it certainly goes back this whole century and, later part of last century, I think. People are much more willing to criticize the justices, to criticize the legitimacy of the institution. So far, they haven't done any actual, expanding the size of the court or anything like that, but you hear about it more and more often. We should, expand. We should add 4 justices. We should add a justice for every justice over the age of something. I mean, a bunch of different approaches out there, and I think they're unfortunate. I think and I don't blame one side or the other. Everybody does it. I mean, the conservatives attack the middle judges as much as the liberals attack the conservative judges. The conservatives tend not to attack the liberal judges anymore, other than just say that they're just wrong, because they're not really trying to sway them. I think they're trying to keep the 6-vote conservative bloc as much of a bloc as they can. But I think it's unfortunate. But there's no question it's increasing. And I think, you see things like, death threats against judges. It's not just the Supreme Court. It's broader, but it's also at the Supreme Court level. And I think it's much more likely now that when somebody disagrees with the decision, instead of just thinking it's wrong, they'll say it's illegitimate. It's a political decision. It's not a legal decision at all. And I don't know, if there's a lot you can do about that, but I just think it's a very unfortunate in both directions.
Do you think the institution's been tarnished?
Well, if you look at the public opinion polling, yeah, clearly it's been tarnished. It still, I think, has higher approval ratings in Congress, but that's not saying much. But yeah, it's not. It used to be. When I first started practicing, which is a long time ago, it was people didn't criticize. Not nobody did, but basically people didn't criticize the Supreme Court. They might criticize particular decisions. Look at Roe versus Wade, which a lot of people thought was wrongly decided, ultimately got reversed, whatever. I'm not arguing one side or the other. But even the people who thought it was wrongly decided mostly were not attacking the justices, a little bit, but not nearly the way it has been since then. And when it was reversed, there were a lot of attacks directly on the justices who voted to overturn it. Instead of just saying they were wrong, it was, they were wrong and they're doing it for political reasons or religious reasons or other kinds of things. And I think it's definitely tarnished the institution. And I think, as somebody who respects all of these institutions, I think it's a very unfortunate development.
So clearly we've stayed away from going in depth to a lot of these decisions because that's just not the intention of this particular podcast. Really, the purpose of this was to show how curiosity, and in a nonpartisan way, and hopefully I've espoused that, can really advance a conversation, whether people agree with the answers or don't agree with the answers. It's just that people can have these conversations. If there's no goal other than to understand and ask, curious questions and listen and ask follow-up questions. And I really appreciate you doing this with me today to sort of practice that. This is the first episode we've done, and we may do some ones in the future similar. So, because in the past, we talk about the process of conversation. We don't talk about the content. And here today, we talked a lot about the content. So my last 2 questions for you. What is a concern, if any, that you have about the current Supreme Court? And what is something that's a positive takeaway that you feel, if any, about the current Supreme Court?
The concern I have is something I mentioned just a little bit before, these proposals to change the court. I think, under the Constitution, there's no set number of justices, and the number has changed over time, although it's been 9 for a long time now. I think, And I absolutely understand the frustration on the left's side, where there's now a pretty solid 5 to 6 judge majority on the conservatives' side of the court. As I say, I think sometimes it's misleading to talk about conservative and liberal, and sometimes it's hard to predict what the effects of decisions will be, whether they really do help Democrats or Republicans. But broadly speaking, there's still, I think, a general sense that there are conservative justices and liberal justices. And right now, the liberals are in the minority. There was a long period of time when the liberals were in the majority. Right now, they're in the minority. It's frustrating to be in the minority. It's frustrating, but for the justices, you can see it in their opinions. It was true on the other side. The conservative justices, when they were in the minority, over time, their opinions got kind of more and more strident, the dissents. And you're seeing that happening on the liberal side. That all I think is healthy. That's a perfectly healthy development. I think the solution to add more justices would be a very troubling one, because once it starts, it won't stop. So if the Democrats win and they add 4 more justices, so now they are winning 7 to 6, the next time the Republicans win, they'll add 3 more on their side or 4 more on their side. So they'll, and you'll end up with a court with 30 or 40 justices if this keeps happening. And I don't think that helps anything. I think it's, it's the wrong solution. And it goes back, Roosevelt threatened to pack the court, and there was a big negative reaction to it. But the court also switched its approach, so it's not clear exactly, what happened there. But that concerns me more than any individual decisions. I disagree with some, I agree with some. I think that's inherent in the judicial process, unless everybody's different. Everybody has slightly different places where they draw the lines. What do you think about term limits? Well, you'd have to change the Constitution. So I wouldn't be against them in principle as long as it was just one term. Because I think if you could get reappointed, then you do get the political pressure. What do I have to do to get reappointed? So if you just said justices serve for 15 years, or justices have to retire at age 75 or whatever, you'd have to change the Constitution, because that's not what it says. But if you did that I think is fine, because you still have no political pressure on the justices, because nothing they do can affect how long they're going to serve. So I wouldn't do anything that introduces politics more overtly into their decision making. But I think it's fine if you want to, we've mostly been pretty lucky. I think that judges, as they've been kind of losing their faculties, have been resigning rather than kind of sticking it out. But if you had a judge who really was senile, you'd have to impeach him. And part of this is Congress hasn't, shown much stomach for impeaching, which I don't think they should do for individual decisions. But if you had a justice who was, physically or mentally incapable of doing the job, that would be different. In terms of positive developments on the court, I personally think the unitary executive decisions are correct. I think that's been a healthy development. I think it's unfortunate that it had to come under President Trump, because I think that makes it even easier for people to treat it as all this political, when, one, I don't think it's political, and two, at the end of the day, it has nothing to do with Trump, because it'll apply to every president. But I do think that that's a healthy development. I think in general, the courts become more textualist, which is my own personal view of how things should be. And you can, there's plenty to still argue about what the text means. But to me, at least, that limits the judge's discretion, or at least makes them tie it to something, rather than just sort of be like some kind of super legislature of 9 people who get to do whatever the hell they want to do. Dan, I've been waiting the whole session to say thank you, Danny, from Billy, since that's how we started. Thank you so much. It's not only great to have a conversation about it, but it's also great to hear from a wise man a perspective that, I don't think is linked to your own ideology. And when it is, you shared. And that wasn't left-right. That was textualist versus originalist, or a living, breathing document guy. So, and I hope the audience sees this conversation in that context. Unfortunately, I think this creates more questions than answers, because this is very complex. And it almost
requires a decision by decision discussion, or at least for some of the key decisions. So we can really sort of get into, why did the justices do this? Was it a textual thing? Do you think that there was any bias? Why not? Et cetera, et cetera. But that's not the focus of the Connection Effect podcast. We're really all about the business of just, connecting with each other and understanding, not trying to win. And we believe it's a more connected society if we're able to have these conversations. So thank you so much for being here, and I look forward to perhaps our next conversation.
That would be great. Thanks so much for having me.
Before I let you go, just a reminder of what we set out to do at the top of this podcast. Usually, the Connection Effect is about the process of a good conversation, not the content. And today we flipped that because I wanted to show what it actually looks like to stay curious on something hard rather than just talking about it in the abstract. But I'll be honest with you, that wasn't the whole reason I did this. A lot of people today are quite anxious about the Supreme Court. They hear about a ruling and their gut tells them it's political, it's rigged, it's not on their side. And I wanted to give those folks a little more context than they'd normally get. A look at how a justice actually thinks through a decision. Textualism versus originalism versus a living constitution. And how often the non-legal noise we assume is driving these outcomes may not be there at all. Not to tell anyone what to think, just to hand you a better set of tools before you decide what you think. This was a different kind of episode for us, and honestly, I don't know yet if it's a one-off or the start of something. So I'd love to hear from you. If this was useful, or if you want to see more conversations like this on other topics with other guests, let me know. Comment on Substack or send me an email. It'll help us figure out whether this is a lane worth going back into. I'm Bill Groner, and this has been The Connection Effect.